We're going to start with the Pledge of Allegiance. All rise. Pledge of Allegiance to the flag of the United States of America and to the republic for which it stands, one nation,
under God, indivisible, with liberty and justice for all. All right. Thank you, Vice Chair Thrower. I think you stepped in there. I've had some technical difficulties. I switched devices, so hopefully you all can see and hear me. Welcome to the 2020 Charter Review Board, Hillsborough County Charter Review Board meeting for the month of October. Thank you all very much for your flexibility in allowing us to move this month's meeting back a little bit further in the month than we normally would have it. At this time, I'm going to ask for the clerk to call roll call attendance for us to ensure our quorum.
Good evening, Narain.
Present.
Barry. Bryant.
Present.
De Laverne.
Present.
Big.
Here.
Fox.
Here.
Johnson.
Here.
Mueller.
Here.
Scarola. Scarola.
Here.
Shaw. Shaw. Stewart.
Here.
Thrower.
Here.
Wood.
Here.
Yates.
Here.
Thank you. You have a quorum.
Thank you very much. Okay. Do we have any public comment at this time? I can say that unless things have changed as of 5:30 this evening, we did not. But as been custom, we will check back at the end of the meeting to see if we have any public comments at all. At this time, we have the minutes. Everyone should have received a copy of those from the last meeting. Do you need a moment to review, and is there a motion to approve those minutes if everybody is good with them?
I move adoption of minutes.
I'll second.
I'll second that.
We have a motion that has been properly seconded for the adoption of last month's minutes. You ready for the question? All in favor by sign of aye.
Aye.
Aye. Any opposed? All right. Thank you all very much. We're going to move on.
Excuse me, Mr. Chairman. Mr. Chairman, who had the motion and the second? This is the clerk.
I believe it was Representative Figg with the motion and, excuse me, Mr. Thrower with the second.
Thank you.
No problem. Okay. Members of the board, last month we had the start in our actual public comment, further discussion about the Civil Service Board that used to be in place here in Hillsborough County. And as a result of your vote, we've agreed to allow Mr. Ryan Barak, Attorney Ryan Barak, to come back and talk to us with his proposal for the Charter Review Board. The county has asked that Attorney Thomas Gonzalez also come in and talk about the Charter Review Board to give us a little bit of the history, where we've been and where we are today. As many of you know, it was via legislative act that the Charter Review Board was removed, excuse me, not Charter Review Board, but the Civil Service Board was removed from Hillsborough County and replaced with the current system that's being used today. So as the rules would have it, we're going to allow Mr. Barak 5 minutes to present. Mr. Gonzalez would also have 5 minutes to present. And I'm going to extend to Mr. Barak a 1 minute opportunity to rebut before we get into our formal discussion today. So at this time, I will turn things over to Mr. Barak to have his 5 minutes to talk about his proposal. Mr. Barak?
Thank you, Chair and members of the board. My name is Ryan Barak, and I am again here before you this evening to discuss the civil service system and the need for the formation of a citizen review process for the termination of county employees. And that's really what this is about. It is a mechanism to enable the citizenry to review terminations of county employees who, let's be clear, work for us, not for the various elected officials or the county administrator. They are our employees as members of the public. During our last meeting, there was a discussion of whether or not this board had the ability to place an item on the charter because as currently enacted, the legislation authorizing the civil service system, and there is a civil service system in Hillsborough County, it's just a different one than what there used to be, requires that all of the appointing authorities adopt the same system. And the reality is that a number of counties and a number of charters have contingent provisions in them, which is what we will need to make any changes at all to the current system. Any changes at all that are made to the current system by the county administrator or by any of the other appointing authorities require them to be adopted broadly. And that is that the fact that it is contingent is not an impediment to it being on the ballot. I was actually last evening looking at my niece's ballot for Miami-Dade. And right now, the Miami-Dade ballot has a contingent provision on there associated with the creation of nonpartisan political offices. And that is something that would require a change in Florida law to come into effect. And that doesn't mean that it can't be there. I cited in the letter that I sent to everyone 2 other provisions in Florida law where county charters have contingent provisions, and I know there are more. The primary problem with the current system is that it uses these private arbitrators who are not accountable to anyone. And since my original letter that I sent to you all, I've learned that the county was able to provide me with their list of arbitrators, half of whom are not lawyers. Of the arbitrators that have actually been selected, in this case, they have 4 arbitrators who've been selected. 2 of them are not lawyers, 2 of them are lawyers, and they are all older white men. And so it is not an arbitration panel or system that reflects the diversity of Hillsborough County. Rather, it is out of county decision makers. Of the decision makers that have been selected, only one of them is even a resident of Hillsborough County. The rest of them are non-Hillsborough County residents. The current county system is unfairly biased against county employees, because if the county can prove a violation of any single county rule, policy, or regulation, the decision maker is required to uphold the discipline in its entirety. There is no mechanism in the current rule for the decision maker to think, gee, that's too extreme, gee, that's over the top, we should do something less. And that is unlike Pinellas County, that is unlike most systems that allow for an examination of true just cause. The Hillsborough County system says that the referee may not reduce or otherwise modify the action in any way if they find that there was a violation of any county rule. I would finally note that the county system utilizes this bizarre summary judgment procedure where there's a hearing and the employee is required, and I want to quote this, to present evidence submitted through written testimony, which shall be under oath or under penalty of perjury, and in the form of an affidavit or declaration, or a deposition or hearing transcript from other proceeding, except the testimony offered as an admission by the opposing party need not be sworn if properly authenticated. Now, I would submit to you that that level of complexity and confusion is not appropriate for a system that is designed for employees to operate it without counsel, which is in theory how this system is designed to work. It is a fundamentally unfair system. The summary judgment is a problem. The system should be confined, reconfigured to have county residents being the ones who make the decision, not out-of-county people who are hired who have no relationship to Hillsborough County. And I think that's been about my 5 minutes. I'm happy to, so I guess I'll reserve the remainder of my time. Thank you.
Yeah, thank you, Mr. Barrick, and I apologize for not pronouncing your name properly. Okay, Mr. Gonzalez. I'm going to recognize you to have 5 minutes as well.
Thank you, Mr. Chair. I'd like to begin by saying I am coming tonight at the request of the the county attorney, but I want to make clear that by way of full disclosure, that in the context of adopting the new system, I represented several of the constitutional officers, including the clerk and the sheriff and the tax collector and the supervisor of election. And so I want to make sure everybody understands that although I'm not speaking on their behalf tonight, I have a history of having been involved on their behalf in this process. And for that reason, I want to start with correcting what with all due respect is just a lot of wrong statements of law that have just been made. And the biggest one is that I read that Mr. Barrick had talked about that the county commission had the authority by statute to establish civil service systems, and that is in fact true. Chapter 120, section 125.01 specifically says that, but it says that with the introduction that the legislative and governing body of a county shall have the power to carry on county government to the extent not inconsistent with general or special law. This power includes, but is not restricted to, the power to, and one of those powers is to establish the civil service system. So the power of the commission to establish the civil service system has at all times been limited by the fact that it can't be inconsistent with general law. And in Hillsborough County, for as long as there has been this statute and that power, the legislature has decided that the system of disciplinary appeals in Hillsborough County is going to be uniform, and it's not going to belong to the county. And it's as simple as referring to the statute, the latest revision of the civil service system that was enacted in 2014, the last revision before its abolishment. And it specifically said, as all the laws have said, that the provisions of this act, that this civil service system, apply to all classified personnel employed by the following agencies or authorities, and then it lists every single authority and board in Hillsborough County, beginning with the commission itself, the county administrator, the clerk of court, the supervisor of elections, property appraiser, the clerk of the circuit court. So the authority of the county to establish the civil service system in the context of the reality of what the legislature did, because the Florida Constitution says that the legislature can establish civil service systems for all local governments. And they acted and they established one, and they said there was going to be one in Hillsborough County for all the agencies, and it wouldn't be controlled by any of the agencies. And when in 2019, the legislature adopted the statute that abolished the civil service system, when Mr. Barrett tells you that there is a civil service system, there's in fact not, because the statute specifically says that system and that board is abolished, and it says that any agency or authority previously covered by the civil service laws, which is all those authorities, must provide a fair, neutral, and impartial system for administering employee discipline, the suspension, involuntary demotion, or dismissal and appeals of such discipline. The system for doing this will be uniform for all agencies and shall provide a tenured employee with substantially similar protections and rights as set forth in section 11 and 12. And that was in fact done. After a great deal of work, there was an agreement by all these agencies, including but not only the county, that this was a system that was going to be, and the law specifically said that it will guarantee substantially similar protections and rights as set forth in the civil service law. And so that's what everybody was doing. That's what the county commission voted on. That's what's enforced now. And so it's not a subject that the county commissioners can take upon themselves to say, we're going to have a civil service system, because they are bound by statute to this system, and this system can't be changed. And beyond that, the allegations that are being made now with respect to the current system, first of all, with respect to the things that Mr. Barrick is complaining about, sorry, I'm getting is someone speaking?
No, sir, that was 5-minute time.
Okay, I'm sorry. Then I will. Then I will leave it. I will leave it at that, as saying that the system that is currently there and the things that are complaining about, those are in this system now because they were put in that system before by the Civil Service Board when they held sway, and they are there for that reason, and they are there as part of it. And this system is consistent with a system that's used by organized employees everywhere, and that is that you go to a system of arbitrators, and those arbitrators are provided by AAA, and the contention that half of them are lawyers and half of them are not, that's the same situation you have with the civil service system, because there might not be any lawyers. And no one said that lawyers have all the wisdom in the world. And for all those reasons, I think that this is, in fact, a matter that's beyond the charter review system, the commission, and it is a system that's fair, and it's agreed upon by all of the agencies and authorities that are participating in it. Thank you.
Mr. Chair, I have a question if I can have the floor at some point. Jamie Scarola.
I'm going to go ahead and ask that question, Mr. Scarola.
Okay, thank you. Mr. Gonzalez, thank you for coming and giving us that information tonight. It's not really my expertise at all, so I apologize if this question doesn't make any sense. But first thought I had was, is there civil remedy for an employee beyond the current system?
I think that's a great question, and the answer is with respect to what it is. It all depends on what contractual rights you have, and the rights of the employees covered by these authorities are provided by the agencies that employ them, all the different employees. And so the simple answer is no, sir. That's the whole point of the system, is to have this.
Gotcha. And can anybody, including Mr. Gonzalez, confirm that the county's cost has gone from $89,000 per event to $15,000 per event?
I can speak to that. That is not an accurate representation of the cost.
Okay.
Ms. Ferris, can you add to that? Can't hear.
Muted.
That Ivy Martin at the last meeting had some of those documents. So I'm not sure what Mr. Barrick is saying, that it's inaccurate with them.
Well, the cost of having citizens serve on the board.
Oh, one moment, Mr. Bragg. Okay. So, Mr. Scarola, are you done with your question, or do you have any further?
I'm going to go ahead and put a motion on the floor just to have it there. Is that all right, Mr. Chairman?
Let's go ahead and have Mr. Barak do his rebuttal. I'm going to give him 2 minutes since Mr. Gonzalez went a little bit over, and then feel free to make your motion.
That's great. Thank you.
All right. Mr. Barrett, the floor is yours.
Thank you, Chair. I briefly want to address the fact that Pinellas, the city of St. Petersburg, the city of Tampa, Pasco County, all of the surrounding local governments all have boards that are made up of citizens that decide these issues. The fact that appointing authorities and elected constitutional officers don't want anyone outside reviewing their termination decisions should not be surprising to anyone. But we, you, the citizens, should have the ability to decide if we think that's the way it should be. And again, as I said before, this is a process. It requires consensus. It requires a building across the various offices to do this. But the first step is, what does the county think about this? What do the voters of Hillsborough County think about this? And so absolutely the first step in that process is to have the citizens of Hillsborough County say, this is the process we want to have. And then it does have to go to those other offices, absolutely. But this is the first step in the process to accomplish that. So this system is flawed. This system does not work well. It actually does cost more. The prior costs were staff costs associated with the civil service staff. There was a large staff. employing a board, as I have suggested should exist, would actually cost less, because right now the county is paying that decision maker. If we use citizens, we don't have to pay that decision maker. So the cost per hearing will be less. It absolutely will be less, because you won't be using all of the money to buy this person's time. And that's really where the cost is. So I want to reflect that the cost will go down with a citizen-led panel. Thank you.
Mr. Chairman, may I ask that to just make a couple of points in response to these points that are being raised now by Mr. Barrett?
Members, anyone have any unreadiness or concern with that? I see all the head shaking. No, Mr. Gonzalez, yes, you have 2 minutes as well.
Yeah, then just very, very briefly, with respect to the contention that the county commission could adopt something and then it would, quote, go to these other authorities, that's just absolutely not true, because there's no provision in the law, the statute that was passed by the legislature, that would allow that, because the system is established now pursuant to that statute. With respect to the involvement of staff, and I've practiced before the Civil Service Board on behalf of any number of agencies for a long, long time. And with respect to the hearings that were conducted, that staff that isn't there anymore, including a lawyer for the Civil Service Board, was getting paid throughout that process, and they're not part of the process at this point in terms of what's going on. And finally, with respect to the experience in other counties, the whole point of the arbitrators was to get a third-party neutral that is not appointed by the appointing authorities, because the civil service boards are appointed not by employee groups and not by the employees themselves. They are appointed by the governing authority of those jurisdictions. Thank you.
And Mr. Marino, I just want to point out that is what Mr. Gonzalez said, that is not accurate with respect to Pinellas County, for example.
Thank you, Mr. Barack. All right, members, you've kind of heard the discussion. I'll start with Mr. Scarola. You had a motion.
Okay, thank you, Mr. Chairman. So, board members, in reading the materials that was provided to us, the original process started in 1951 and was not even begun to be changed until 2014. And I think it was finally not until last year that the new process was put in place. And all of the constitutional officers have signed off on this. I thought from the beginning that this was wholly inappropriate to take up. I said it from the first day at our first meeting, to take up as the Charter Review Board. And so I'd like to make a motion that we not take this any further. I think Mr. Gonzalez's expertise speaks for itself. And I would like to leave that as the motion.
Okay, members, you've heard the motion. Is there a second? I see Mr. Wood. He has 2 fingers up. I'm going to take that as a second. All right, let's move to discussion on the motion, which is to not adopt this. Is there any discussion? I see Representative Figg, you're recognized.
I was looking for my hand, thank you. I fail to understand the need for stopping the discussion when the discussion has been completed. I, for one, have not, for example, had opportunity to ask my questions yet. Our purpose, is my understanding, is to hear.
Oh, no. Okay, it's just the representative. She's the only one in timeout right now, huh? Because I see everybody else. Oh, man. Oh, boy. Technology issues. Okay, in the meantime, Attorney Yates, you're recognized.
Thank you, Mr. Chair. I think I'm in agreement with where I think Representative Figg is going, and that some of us might have some questions. I mean, I, for one, wrote some down. And instead of just moving along, I think our job is to talk about these issues, learn more from the 2 gentlemen that are arguably experts on this topic. So I have some questions. I know Ms. Figg might too when she gets back on. I don't know if anybody else does. So I'm not saying we should table Mr. Scarola's motion, but if we could just have a minute for discussion before that, maybe that would be great.
Okay. Mr. Scarola, I see Ms. Spratling, you recognize.
I just also wanted to say that as well. I particularly am concerned and would like to be able to have addressed before we vote on any motion to not have this conversation further about, I'd like clarification around our authority. We've had some comments to indicate that we didn't have any authority, and then some comments to say that we did have authority. So I'd definitely like to have some clarification around that as well.
Mr. Scarola, did you want to table your motion? We can come back.
Mr. Chair, I'm happy to allow the conversation to continue. That wasn't the intent. The intent was simply to put it out there so that we have a direction, at least from my point of view. But no problem with the conversation.
All right. So you're okay with us tabling it for now, and we'll just move into some questions if individual board members have questions for the two attorneys that are presenting tonight. We'll start. Ms. Yates, I see your hand. Thank you, Mr. Scarola. I'll recognize you, Ms. Yates.
Thank you. I second what Ms. Spratling said, because I heard inconsistent statements about the authority of this board in moving forward with any type of change. So if both gentlemen could address that specific issue, I think it would provide at least clarification or make us clarify our questions a little bit better.
Sure. And I'll ask that each one of the attorneys, please just try to limit your response to about 45 seconds. We'll start with you, Mr. Barak.
Okay. Thank you, Chair. So the system as enacted requires that it be uniform across all of the appointing authorities. But it doesn't say it is fixed in time and exists only as it exists in this moment. It just says that any changes that are made have to be changes that are adopted by all of the entities. So absolutely, the county as one of the entities can say, we want to do this thing differently. And the other entities then would join on and that change would occur. But there has to be a mechanism within that system for it to change. Otherwise, it will never change. It is fixed for the existence of the system. And that's not what the legislature says. It simply says that it shall be uniform across all of the entities. So absolutely, the county administrator, the county as an entity has the ability to change it. And the way to do that they can do that is through the charter. And then but I want to be clear, it is contingent and it only takes effect upon the adoption of those changes by the other appointing authorities.
Thank you. Mr. Gonzalez. You're on mute, sir.
The wording of Chapter 219-183, which abolished civil service, says, any agency or authority previously covered by those chapters must provide a fair, neutral, and impartial system. The system for administering employee discipline and appeals will be uniform for all agencies and shall provide a tenured employee with substantially similar protections and rights as set forth in the statute. The references to statute, the authority to alter that system rests with the legislature. There is nothing in here that calls for a change in the system any more than the civil service system could have been changed by anyone other than the legislature. It's the wording of the statute itself, and this idea that has just been stated explicitly that these agencies can get together and contrary to an act of the legislature, adopt some kind of change is just not supported by any theory of law or anything in the statute.
Thank you. Ms. Spratling, did you have a question, or did that?
I mean, I think I'm understanding that what Mr. Barrick is proposing that we could do is create a contingency that would allow for this issue to go back in front of voters if there's ever a legislative act that would allow, that would remove this restriction. I think that's what I'm understanding. If I could get a piece of clarification of that, because I understand the contingency, I definitely understand that, but I'm understanding what I'm trying to still understand exactly what that contingency could look like.
Thank you, Member Spratt. So
one moment, Mr. Barak. I want to make sure there's not any. Okay. All right. You're recognized to answer that.
Thank you. So the contingency is not all. I don't think it. Contrary to what Mr. Gonzalez says, the system that exists now, all of the appointing authorities had to agree as to what that rule system is. They all had to adopt it. There was a motion in front of the Board of County Commissioners where they adopted it, and all of the other appointing authorities signed letters saying we're adopting this system that exists now with the hearing officer and that whole thing. That was all adopted by each of those people. That language about the summary judgment, about the hearing officers, none of that appears in the Florida statute. None of that was enacted by the Florida legislature. That was all agreed to by the various appointing authorities. And so the various appointing authorities can agree to something different as long as it provides at least the same level of protections as the old system did. And that happens. And the old civil service system, they would rewrite those rules on occasion without action of the legislature, but the board itself would rewrite those civil service rules and adopt them. And similarly, a citizen-led panel could adopt those new rules. But the contingency is, upon adoption by the other appointing authorities in Hillsborough County, there shall be a citizen-led disciplinary review panel.
Thank you. Ms. Yates, you're recognized.
This would be directly following that question. So does that mean that all of the agencies and authorities would have to agree to this too?
Absolutely. And I apologize. May I answer, Chair?
Yes, please.
Okay. Yes, all of the appointing authorities have to agree. For any change to occur, all of the appointing authorities have to agree. So, for example, if there was a decision made that rather than allowing non-lawyers to be these arbitrators, we wanted to make sure all of the arbitrators were lawyers, all of the appointing authorities would have to agree to that change. If they wanted to abolish the summary judgment procedure, or say that you don't have to use affidavits, all of the appointing authorities have to agree to each and every change to that system.
Thank you, Mr. Barak. Ms. Representative Figg, I see your hand, but I'm not sure if you're back with us.
And may I respond at some point to what's being said?
Is that better?
Okay, we can hear you now.
Am I recognized?
Yes, you are recognized, Representative.
Thank you. I need some legal clarification here on a couple of points. I understand that the legislature abolished the special act, as is their duty or is their responsibility. But how can the same legislature dictate to the county, a charter county, and separately to the constitutional officers, what system of civil service shall follow from that? Can you explain that, please, Mr. Gonzalez or Mary Helen, whoever wishes to answer the question?
We're going to start with Mr. Gonzalez. I apologize. You're recognized. It's a little difficult with all these screens here. And feel free to rebut also.
In direct response to Ms. Figg, the statute that talks about the powers and duties of the counties specifically says that all these powers that the county has are only to the extent that they're not inconsistent with general law. And the Constitution gives the legislature the right to promulgate systems with respect to employee discipline. And so with respect to this idea about what the legislature can do, the legislature can in fact do that. And it reserved the right to do that in 12501, which is the statute that talks about counties doing that. So yeah, they have the power to do these things unless the legislature has decided that would be inconsistent with the law. And again, with respect to the things that are being said tonight and what's being urged with respect to all these changes and those kinds of stuff, they didn't come from the civil service statute. They came from the civil service rules that were adopted by the civil service pursuant to the authority they had under the old statute. And that's why they're there, because the statute says that you have to have the same rights and privileges that you had before. And again, with respect to this idea of what can be done, what I'm hearing Mr. Barrick say is that somehow the Charter Review Commission can bind future county commissions as to what they're going to say, because the contingent provisions that he's talking about in Broward and those kinds of stuff, they only talk about what the county commission can do in terms of what they may. And I don't know of any authority that a charter review commission has to put on the ballot something that will bind a future commissioner in terms of how he or she is going to vote and what they're going to do. But with respect to this whole idea of that there was something that allows this thing to be organic in terms of all these authorities having to get together every time one of them wants to change it, that's just not in the statute. And there's nothing in the statute that has anything that allows, because it says in the statute, the will of the Florida legislature, which was elected by the people as well, has said, here's what you're going to do. You're going to do a system that's going to be uniform, and it's not going to be. Mr. Barrett talked the last time about someone being the big boy on the block in terms of doing these things, and the county employs the most employees, so they get to do it. That was never part of the civil service system or this system in Hillsborough County, because it was always going to be about all of these authorities and counties that were in there.
Representative Fig, did you have a follow-up?
I have something of a follow-up. I was very disturbed by the statement that was made that of the hearing officers, I'm not sure that's their correct title, are older white men. Well, I'm really bothered by that. But I'm not sure that the solution is to try to put together some kind of new civil service board. The solution is whoever makes these choices should look at a broader perspective. And how do we affect that change?
Okay. Members, anybody else with any questions or comments? You can use the hand function or put your hand up in the screen. Mr. Mueller, you're recognized.
Thank you. This question is for Mr. Gonzalez. The summary judgment process, was that a part of the previous civil service process?
Speaking from my memory, and I don't know, maybe Mr. Barrett can do, because he was one of the attorneys who was working with the civil service board at the time to carry out this function. But I do remember that there was the establishment of a summary judgment procedure that would allow for the matter to be decided before it got to a hearing at all. And yes, sir, it was part of the process, and it was in fact cumbersome. And you went through a lot of time to get through that process.
Mr. Mueller, did you have a follow-up?
How often, if anybody can answer, how often is this summary judgment process used? And in fact, since the new procedures come forward, has any cases been decided on a motion for summary judgment that would cut off someone's right to a hearing?
No, and I would say that when somebody complains that the process is too cumbersome, the idea of the summary judgment was to basically not to have the employee prevail before a hearing. It was to basically say that we didn't need to have a hearing because it was so clear that we didn't need to go on. So it was intentionally cumbersome. And no, sir, I don't know of a situation where the summary judgment has cut off somebody's right to a hearing.
There's only been one hearing under the current system, and the employer moved for summary judgment. The employee was not represented by counsel, and I believe there was they were allowed to make a statement during the proceeding, but and so whether or not it was technically a summary judgment, it was in the nature of a summary judgment resolution. And that was decided by arbitrator Chris Schulman. And I believe that's the only one that was decided. And so while it may not have technically been a summary judgment, it was in the nature of a summary proceeding.
Thank you. Mr. Mueller? Mr. Mueller, any further questions?
No, not at this time.
Thank you, sir. Members, any other questions? I don't see anybody's hands in the system. I don't see anybody waving at me. We do have a motion that is on the floor that was tabled so that we could have a proper discussion and question the attorneys that are here with us. Mr. Scarola, do you mind repeating that motion for us?
Sure, Mr. Chairman, thank you. So I believe that it's inappropriate for us to continue with this process, and I would like to make the motion that we simply don't take it any further. And we've learned a lot of good information here, thanks to both attorneys, but I don't think this is a matter for this board. And the motion is to not continue with it.
Okay, thank you. I know we had the motion, it was properly seconded, so we are back on that motion. Is there any discussion amongst the members, just the members, on the motion to not take this issue up? Meaning an affirmative vote tonight would be for us not to do anything. No one in discussion? I don't see any faces. Okay, Mr. Mueller, I see your hand.
Yeah, just quickly, I think it was at our last meeting, it was Board Member Shaw that this was important to, and I don't think he's here today. Was he going to be coming in later, or?
He had indicated that he would be here at about 6:30 today, but it's 6:44 right now.
Well, like I said, I just know that he seemed to be pretty interested in this, and you know, it's unfortunate he's not here, so he could at least voice before, you know, this motion is voted on.
Agreed. Ms. Stewart, you're recognized. You're on mute.
Oh.
Ms. Stewart, you're on mute. We can't hear you. And we still cannot. Let's see.
She has her microphone muted.
Yes.
Okay.
Did I do that?
Okay. Are you on two? Turn down the volume on one of your devices. I show you twice on my screen. That's where the feedback's coming. Okay, so now you're double muted, and you just need to turn down the volume on one of the devices that you're using so you don't get the feedback.
I'm only using one.
Oh, wow. We show you twice. Okay. Okay, Ms. Stewart, how about now?
Okay.
All right, perfect.
I don't know what happened, but in any case, I was going to ask Mr. Scarola if you would consider postponing the vote on his motion to the close of the meeting in case Mr. Shaw appears.
Okay, now with my volume on, no problem at all. Edith, thank you.
Thank you.
Okay. We'll continue with debate if you'd like. Any other comments? All right. So we'll pause this towards the end. We are close to the end, and we'll move into new business. Does any member have anything they'd like to bring before the body tonight?
Mr. Chair, I'd like to at least bring up a matter, if it's possible.
All right, Mrs. Scarola, you're recognized.
So board members, you'll recall that we left unfinished business about general representation for Hillsborough County because of the time constraints that we had before. And I only want to make mention that it really, I do think that that's a primary purpose of this board, and I'd like to see if we can continue those discussions, maybe in a future meeting, maybe pick some target dates, and continue on from where we left off.
Which unfinished business are you referencing? I'm sorry, I'm a little lost.
Well, in particular, it was about the subject of representation, and so back to the Board of County Commissioners and the makeup of the Board of County Commissioners. If you recall, we were under time constraints, and so we did not. We came to a conclusion that we weren't going to take it up for this election cycle, but not necessarily for the next election cycle. So at some point, we'll need to have that discussion again, and I thought it's worth bringing up to talk about when that might be.
I got you. So in other words, when we were working before, that was under the impression that whatever we did or recommended to the public would be for this ballot here, November 2020. And so we operated a little quickly, but we have until February to make decisions about what we may want to place on the 22 ballot.
That's correct. Thank you, Mr. Chairman.
Understood. Mr. Wood, you're recognized. I see you.
No.
No? Okay, you're unmuted. All right. So is there a motion for us to take a look at that again? Mr. Scarola, are you using that in the form of a motion? Do we bring that
Sure,
up at a future meeting?
I'll make that as a motion to take it up at a future meeting.
Mr. Ray, this is Robin. I'd second that.
Okay, we have a motion that has been properly seconded that we take a look at the makeup of the county commission for a future meeting. Any debate, discussion? And you can use the hand feature or you can try to wave at me here. Okay, I don't see any debate. Are we ready for the vote? Okay. We'll do a roll call. Wait, I see debate. Okay, I see Attorney Yates and then Attorney Spratling.
Not necessarily a debate, more of a comment question on the motion. Is this so we can bring any further people that we need to talk to about this issue or ask any questions on that? Is that what your intention is on bringing it back up so we can bring this back forward for discussion and maybe call any speakers that we would like to hear from on this issue, those kind of things, Mr. Stroll? I just need clarification, I guess.
Ms. Yates, absolutely. The idea is to simply open the door and entertain the whole conversation, experts, whatever needs to happen.
Thank you. Ms. Spratling, you're recognized.
Chair, I was just trying to get your attention to make sure you saw Attorney Yates.
That was pretty good because you were pointing at her and it looked like you were pointing her in a real meeting. So I thought you were waving for yourself. Excellent. Any other debate? Comments? I don't see any. I don't see any hands. Okay. Let's do our roll call vote if the clerk will open up and call the names.
Narain?
Yes.
Bryant?
Yes.
Delaverne?
Yes.
Big?
Yes.
Fox?
Yes.
Johnson?
Yes.
Mueller?
Yes.
Scarola?
Yes.
Shaw?
Yes.
Stewart?
No.
Thrower?
You're on mute,
Thrower?
Mr. Thrower?
Yes.
Wood?
Yes.
Yates?
No.
One moment, please. Motion carried 11-2. Members Stewart and Yates voted no.
Okay, members, by your vote, we will have another discussion at a future meeting about the makeup of the county commission for the 2022 ballot. All right. Any other items that are new for the board? And I'm looking to see hands or wave. Ms. Yates, Attorney Yates, you're right.
Not exactly new, but I see that Representative Shaw joined us again. And I wanted to just make sure that we noted that our minutes from the last meeting, it showed that Mr. Shaw requested data on the civil service cases that were won by employees. And I don't think that was discussed this evening, that he had asked to be brought back. And then I know some of the items that we talked about earlier, I just want to make sure that we have an opportunity for Mr. Shaw to at least get a Cliff Notes version of what he requested from the last meeting too.
Okay. Anything else under new business before we circle back to the motion that's on the floor? Okay. I don't see anything else, so we'll close out new business and we'll return to the motion on the floor that we not adopt any changes to the plan, to the civil service board as it stands right now. The question, thank you, Ms. Yates, about cases, the number of cases won by employees under the current system. Mr. Barrick and Mr. Gonzalez, I don't know if you all have the answer to that. I believe only one case, and I don't want to speak out of turn, has been heard by the current system. Is that accurate?
Yes, Chair. There's only been one case heard under the new system that I was aware of. And in that instance, the county won. I don't know if Ms. Ferris is aware of any others. My understanding is there are 3 other matters where there have been hearing officers selected, none of which have gone to hearing. Is that correct, Ms. Ferris?
I really don't have that information, but that sounds accurate as to what I've heard before.
Mr. Gonzalez, did you have anything to add on that?
No, sir, I don't have any knowledge. I don't have any knowledge of that, nor do I have any knowledge of the percentage that were won by employees under the civil services.
Thank you. Okay, Mr. Shaw, I'm not sure if you had any questions. We have representation from both sides of this issue here tonight. And
I apologize for being late, Mr. Chair. I was in Zoom purgatory with other conflicting Zoom, so that's my fault. And I've looked at the submissions of both sides there, so I'm good. Thank you.
Okay. We have a motion that is on the floor that the Charter Review Board not take up any changes to the civil services system as it is currently set up. That motion was made, it was properly seconded. We were in debate. Is there any more discussion of the issue? Please use the hands feature or wave at me. So members, I will chime in just based off of everything that I've heard. I've taken my own notes tonight. And the concern that I have is that whatever this board were to decide, the direction that you were to go, if you said, hey, we need to create our own system, we are essentially preempted, under my interpretation, by the legislature. All of the civil service boards that have been created around the states, even the ones that were in the 155-page packet that we got, when you take a look at them, they derive their powers from the legislature. And so anything that were to be created would be a contingency or would be in case the legislature agrees to go along with whatever is decided by the people. So in a perfect world, for anyone who's thinking we should move forward with this, we could ask staff to create a system. We could come back, vote on that system, pass it, put it in front of the voters. The voters could pass a system, and then that system would be sitting there waiting for the legislature to decide they're going to allow Hillsborough County to do what it wants to do. This was just repealed in 2019. I don't see the legislature or any of our current legislators taking this up as an issue. And I do agree with some of the sentiments that I've heard that this would be something for our legislative delegation to take up as an issue and to change before we took a look at it. So that's just my opinion. I wanted to voice that as a representative on this board. Any other comments or debate? Okay, I don't see any. We'll close debate. Are you ready for the vote? We will hand it over to the clerk for the roll call.
Narain?
No.
Bryant?
No.
Can I get a little clarification? When you,
Because the
when you're
motion,
saying no, that means that you want to have debate?
yeah, the motion was not to continue the civil service discussion. So if you want to stop the discussion, you would vote yes.
Okay, then I vote yes.
Can we start over? Because I voted wrong then.
That was confusing.
Okay, I'll start from the top again. Narain?
Yes, I would like to stop the discussion. Sorry.
Bryant?
Thank you for that clarification. Yes.
DeLaverne?
Yes.
Fig?
Yes.
That was a yes, ma'am.
Yes, I am voting to continue discussion, if that is correct.
No.
No.
I apologize, and this is my fault as the chair. I should have restated the motion before we move to the vote. Let's start over one more time for the record. So as Mr. Ms. Scarola's motion is to stop the discussion of this particular issue in front of the Charter Review Board. So a yes vote would mean we're not going to move further anymore with the discussion on this particular issue. A no vote would mean you want to continue and would like the board, the staff to create some language for the voters potentially.
You are successful in confusing me, Mr. Chair.
I'm really good at it. So a yes vote agrees with Mr. Scarola that we should not do anything. We're just going to sit. Is that fair? Okay, so in this case, a yes means we're going to stand still. Okay, Ms. Bradley, I see your hand.
Okay. So just with that clarification made, am I able to make a comment then, like kind of a debate comment? Would that be appropriate at this point?
The debate is closed, but since we screwed it all up, I've screwed it all up. Please go ahead and make your comment.
Okay. So along those lines, I'm thinking that, okay, a couple of things. So with our prior act, we ended that conversation, but we always could bring the issue back up if additional information came forward, right? So our decision to end this conversation today does not preclude us from bringing it back up at a future time before the end of our term.
That is correct.
Okay. With that, then I'm clear on my vote, and I appreciate that.
Okay. Thank you. Usually when we have motions, those motions are to do something. So this one is a little different in that we're voting not to do something. So I think that's where the confusion is, as well as my explanation. So I apologize. Any other comments? Okay. Mr. Clerk, three's the charm.
Narain?
Yes.
Bryant?
Yes.
DeLaverne?
Yes.
Fig?
I am voting no. I wish to be able to continue the discussion.
Fox?
Yes.
Johnson?
Yes.
Mueller?
No.
Scarola?
Yes.
Shaw?
No.
Stewart?
No.
Thrower?
Yes.
That was a yes, correct?
Yep. Yes.
Thank you. Wood?
Yes.
Yates?
No.
One moment. Motion carried 8-5. Members Fig, Mueller, Shaw, Stewart, and Yates voted no.
All right. The motion has carried. We're going to stop the discussion at this meeting. We're not going to move forward. Mr. Barrick, Mr. Gonzalez, thank you very much for your time and for your presentations tonight. Very, very insightful. Okay, we switched to order, and we have already handled new business. On this item 7, we have a future business meeting update. What I would like to share with everyone here is that the governor's executive order, basically limiting in-person meetings, has been lifted, effective the end of this month. And so as a result, we have to meet in person. We have to have a quorum and meet in person at our next meeting. I have asked the staff to look for accommodations to keep everybody socially distanced so we can follow the guidelines that have been set in front of us from the CDC and our local health department. But we do have to meet in person once this moratorium lifts. So far, there are a couple locations that are being looked at in addition to the county meeting space on the second floor. So just know that I know we all have the same concerns about what is happening, and we are going to do everything that we can to make sure that when this starts again, that everyone is safe. I would encourage you, if you have a concern or a condition that's going to prevent you from meeting in person, to please let the staff know. You don't have to tell me anything. Just would like to know what that's going to look like, because we won't be able to proceed forward without a quorum, an in-person quorum. And for us, with 14 members, that's going to be at least 8 that have to be present physically. So, just putting that out there for us. Any concerns? Mr. Wood, you're recognized.
Question. Will the people who aren't there physically be able to participate through a system like this?
Yes. Yes, we absolutely will be setting it up.
Okay, thank you.
For that to happen. Any other questions, members? Ms. Yates, you're recognized.
Thank you, Mr. Chair. I know you said, you might not know this yet, but you mentioned that there were places that were being looked at that we could be able to distance ourselves. I have concerns about this, so I'm curious what some of the things that we're thinking about regarding guidelines and those sort of things.
Ms. Cardenas, I know you're with us tonight. Is there any information you'd like to share as far as how that process is coming along?
Sure. There's just a few locations we're looking at. We're looking at the room that we met in previously, the second floor.
I think we've lost you.
Also, all of these is cleaning them properly, so all of the CDC guidelines are going to be followed.
Beth, do you mind starting over, because we didn't hear you?
Oh no, am I muted? Can you hear me now?
No, you're fine on the mute part. You are unmuted. We just couldn't hear you because you broke up a little bit. So do you mind starting over?
Okay. Sorry, technology tonight is not great.
Wow.
So there's a couple different rooms we're looking at. The first is the boardroom on the second floor that we were meeting in before COVID. The second room is on the 26th floor. A lot of commission meetings occur up there. And then the other locations that are being looked at are 2 libraries in downtown. There have been some code enforcement meetings and land use meetings that have been held in those rooms. So they have all been distanced, cleaned regularly. All of them meet CDC guidelines. So we're just figuring out which room is going to be available but whichever one it is, it will be distant, it will be sanitized, cleaned, and everything appropriate.
Great. Any other questions for Ms. Cardenas while we have her? Dr. Fox, you're recognized.
Yes, I just wanted to be clear about the quorum. So we must have 8 persons present in person, no matter how many we have online, correct?
Right.
Yes. And if we don't have those 8, what happens?
I'm going to throw that question to our board attorney.
Well, if you don't have a quorum, there are some limited actions you could take to try to obtain a quorum, but you can't take action if you don't have a physical quorum. So that is necessary.
Okay. Any other questions?
I have a question, Ed. So
yes, Ms.
based on what Mary Helen just said, so if you didn't have a quorum, you could still have a meeting and have people testify as long as other people were on the WebEx, and then take a vote at the next meeting if you had a quorum. Is that correct?
Yeah, you just can't take any official action at all.
All right. Thanks for the clarification, Mary Ellen.
Representative Shaw, I see your hand in the system. Did you have a comment or question?
Yeah, I had a similar question about quorum. Can you give me a sense as to what action might need to be taken at the next meeting, as opposed to what presentations may take place at the next meeting?
Yeah, the only thing that is kind of a holdover right now, there are two things, and then we have our new issue for tonight. The first is looking at closing the loophole on the seat jumping on the county commission. The other is the presentation from our county administrator, which was due for November here. And then the new issue that's come up tonight about taking a look at the districts for 2022. Any other questions or comments?
And our next meeting is November 3rd?
No, the 10th, I think.
Yeah. November 3rd would not be a good idea. I don't think
I'll be a little busy. I'll be just a little busy then.
I think we had moved that ahead of time, but it is scheduled for November 10th at 6 o'clock.
Thank you.
Great questions. All right. As we close down, I don't see any comments or questions. Do we have anybody that has joined us for public comment? I don't hear anything. So, all right, ladies and gentlemen, thank you all very much for your patience tonight. We've had more technical issues than we've ever had before in one meeting. Maybe that's a sign that we do need to see each other face to face, but I'd encourage you all to, stay safe and all the best to you and your families. Thanks again for joining us tonight. The meeting's adjourned.
Good night.
Good night.
Bye.
Have a great night, everyone.